compensation or payment for environmental services, pay, as well as establishing the essentials for the provision of environmental flow. Out of these tools, probably rule was crucial in promoting the rule of law and strengthening the capacities of states to build water governance arrangements worldwide, and flow, which is the one that brought the essential features to implement the concept of environmental flows. Later on, and bearing in mind that water is often shared between countries and unevenly distributed, IUCN started the implementation of a new initiative, which is called EMERJ, Building River Dialogues and Governance, working at the convergence of hydrodiplomacy and multi-level governance to foster new approaches to the management of transboundary waters and strengthening cooperation between states. This initiative is based in 4 specific strategies: demonstration on the ground, learning, dialogues for consensus building, as well as leadership development, and is implemented in Africa, in Latin America, in Southeast Asia, and in South and Central America. Pardon, I repeated America, but it doesn't matter. It's not because I come from there. This initiative has facilitated multi-stakeholder dialogues in all these basins, supported transboundary commissions, and built capacities across the board of water agencies, providing expert assistance through the efforts of the Environmental Law Center, the Commission of Environmental Law, and the other IUCN commissions and networks. And by strengthening and consolidating institutional frameworks and promoting transboundary cooperation, EMERJ, building upon the Water and Nature Initiative, is contributed to enhancing the rule of law in this particular area. In the past few years, a series of important events have happened in this particular regard, and I'm speaking about 2 remarkable ones. One is the entry into force of the UN Convention on the Law of Non-Navigational Uses of International Watercourses, and the other one is the globalization of the Helsinki Convention under the UNECE. Likewise, with the recent adoption of the SDGs, the Sustainable Development Goals, targeting at the implementation of integrated water resources management at all levels, policymakers, parliamentarians, scholars have seen this momentum as an opportunity to further leverage and promote effective management of freshwater ecosystems. IUCN has been working on the promotion of the rule of law and to achieve effective governance of freshwater ecosystems worldwide. It has worked closely with governments, closely with basin commissions, closely with academia, with local stakeholders on the development of the law of freshwater ecosystems. So, the question is now, have we done enough? Has the institution reached the boundaries of what needs to be done in this particular area? Or do we need to do more? I will propose that it hasn't reached the boundaries. Why? Because as the custodian of biodiversity and ecosystems, IUCN should continue to insist on disentangling the dichotomy between ecosystems and water. Without ecosystems, there is no water, and without water, we know what can happen. IUCN should now mobilize, in my humble view, its networks and create the momentum for several issues that my colleagues already referred to, but I would like to insist on. First, I think developing strategic initiatives to promote the implementation of global and regional frameworks and for the realization of the Sustainable Development Goals that are fundamental for this particular area. Considering also the fundamental link of freshwater ecosystems with the oceans, IUCN should promote the implementation of a sources to sea approach. Integrate both areas. IUCN should also work in trying to promote linkages or the nexus approach between water, between the energy between the agricultural sectors, but without forgetting the fundamental role of ecosystems in that conundrum. And finally, facing the imminent effects of climate change, IUCN should intensify its work in promoting adaptation frameworks and tools based on ecosystems, goods, and services. Thank you. Thank you very much.
Thanks to you, Alejandro, once again, as in the other two cases, not only for the content of the presentations that were extremely interesting, but also for time management. Thank you. As we defined before, I will open now the floor for short questions or even shorter comments. But we are facing, I think, one problem, one obstacle, that is that we do not have a microphone for going around with the audience. So what I will have to ask, or maybe we do, I'm not sure.
You could approach over
Yeah,
here.
I will suggest that. If we can get one microphone, that would be. Yeah, the problem is you lose the translation if you speak out of the microphone. That is the problem. So I don't want to put someone in the situation that is not able to. Wonderful. Wait one sec. Yeah, but from here I will have to throw it. So, and I'm not that good. No, it's fine. Then we will open. We do have a microphone, so we will go around the floor. I suggest that we take first 3 questions or comments, go to the speakers, and then one round again until we reach 4 p.m. Mm-hmm. Then we will go to the second round of speakers. Anybody making a question? I just would like to ask first to introduce themselves. I mean, just name, and if you're representing an organization, which organization? If not, your name, and go ahead with the question. If it's specifically devoted to one of the speakers, please say so. Otherwise, you can answer as you please. Mm-hmm. Who wants to be the first one in making a question or a comment? Please don't fight with each other. Yeah.
My name is Owen McIntyre, the chair of the Specialist Group on Water and Wetlands. I have a question for Alejandro. You've highlighted, Alejandro, the work that IUCN have done in relation to the key building blocks of implementing an ecosystems approach to the protection of fresh waters. Work on flows, technical guidance on flows, technical guidance on ecosystem services and payment for ecosystem services. And I want to talk about that myself in the next session. What can IUCN or IUCN in cooperation with a broader community of activists, scholars, etc., what can IUCN do to consolidate this guidance? I mean, what I'm really asking is, how do we make it very clear what freshwater ecosystem legal obligations actually require on the ground today?
Thank you very much. I would like to take a couple of other questions or comments. Are there any? Let's start with that one, and then I'll go again to the floor. Alejandro, it was directed to you.
Thank you, Owen. Thank you. And I guess you know that my view is not going to be absolutely comprehensive on that, but I will start, proposing that there is a further need, in the IUCN network, and especially using the resources, the academic resources, that IUCN has, the Commission especially, to do further research on that. Because, and I hope that you will speak about that, this is an area that is still evolving a lot. And we, from the Secretariat perspective, we are not capable enough to capture that rich evolution that is happening while we're sitting here. So I think that academic research is very much needed. But also we need to be astute enough to use the political resources that this organization has to mainstream that in the political discourse, in the political debate. So to influence, for example, further legislation through legal reform, international agreements through the hydrodiplomacy endeavors and in all the processes that IUCN is participating, bringing together not only the members of the Commission of Environmental Law, that can speak from a legal perspective on this fundamental issue, but from other commissions of the IUCN. I'm speaking about the Commission on Ecosystem Management, the Commission of Species Survival, and even proposing, in this particular area, the World Commission on Protected Areas. One way of implementing the concept of environmental flows could be in allocating or separating specific sections of a river or of a lake. And that idea of connectivity and protected areas is very fundamental. So I would really propose that, insist on further research, apply research, and also bringing together all the networks to continue influencing the political discourse and debate at the national and international level. Don't know if...
Sure. If Carl or Max wants to add something, please do.
One thought that crossed my mind, there was a talk of conventions, and IUCN has had a long and important history in this realm. I've seen in the last, 10, 20 years, another process that IUCN might consider, and that's where conventions often get, the ambition gets downgraded in order to achieve consensus. And you see some very interesting initiatives that are essentially like-minded. So EITI, the Extractive Industries Transparency Initiative, the EU Flag T process, where you have what amounts to a small group of countries adopting binding, very aspirational norms, and then building it out. And when it first happens, it's dismissed. It's an anomaly. But when you get 30 countries or 40 countries, it starts to look much different. And I'm just thinking there might be some room for something other than a conventional treaty process that IUCN could lead with, where you really can be quite aspirational.
Thank you very much. I believe we have first a question here and then one there. So please go ahead.
Hello, my name is Caitlin. I'm from the Environmental Law Center in Bonn. I have a question about the different issues that we've heard today. How can the environmental rule of law actually assist in ensuring that water security will be mitigated in the immediate future? And how can we help prioritize these different issues that you've presented and make sure that water management is actually considered in this whole myriad of issues?
Thank you. Could you move the microphone? Yeah, thank you.
Thank you for the opportunity. My name is Werko Yifru. I'm from the Secretariat of the Convention on Biological Diversity. My question is, yes, countries seemed to have agreed to this concept of integrated water resource management. It's now part of the SDGs. But in reality, especially in the context of transboundary and boundary water resources, countries are more focused on the rights, water rights. They want first and foremost to define what their rights were, vis-a-vis the other co-basin states, vis-a-vis the other water-sharing neighboring countries that they have. And in the meantime, environment suffers because there's always a competition to put some evidence on the ground by building water resource development projects. Some dams could be constructed in places where they could be more wasteful than useful, where there is more sedimentation which makes the dam useless after a few years' time. So for me, I have a little experience in that area. The fundamental issue here that may need help from the environmental law community is defining the water rights. Well, some years, decades ago, we had the Helsinki rules, where we had some parameters, how the water rights may be defined, population, water contribution, etc. But now we even, after having the International Water Courses Convention, the 1997 Convention, we still have little in terms of defining the rights. So how can we help the countries that are sharing water resources in this respect? Thank you.
Thank you very much. There is one intervention here in the front, and then we will go back to the speakers for comments about all of the questions that have been made.
And this is Ambar Prasad Pant from Nepal. I am professor of law at Tribhuvan University. After listening 3 presentations, and it has struck me to speak, to raise few questions related with this. This, resource has been a serious conflict issue in our region between the upstream and downstream countries, between some countries in the region of South Asia, and there is always serious debate, and when the national foreign policy will also affect because of that conflict issue. Now, as we see the standard or parameter just now raised, so far developed at the international level, whether we go with 1997 convention or the earlier one was, as Asia has pointed out, Helsinki, which is globalized. But there is one more development with ILA, that is Berlin Accord 2004. You may be knowing that. So with that, there are 3 different, regulations developed at the international level. Helsinki, which was the initial one, which is replaced by, I should say, Berlin Accord 2004. And then we have UN Convention, which has come into force. Now, when we go into those 3 or 2 regulations, we find different parameters. He's right, he has also pointed out that question. But now, viewing those scenarios, which one of the 2 different instruments that has developed such parameters should be the basis to go into negotiation and resolve the conflict in relation to sharing of the water between upstream and downstream. I think I should say only this much now.
Thank you very much. Go now to our first round of speakers, and I don't know if Max wants to start and then coming in this direction, and that will be the end of this first part of the session.
Well, I think that it is not too much from my background to express regarding the conventions and the relationship with some of the questions that you had and comments. But I have a different flavor for that, and this is it. There is no legislation that could be implemented without understanding what is really going on the field with the people, and some of you mentioned, or the poorest places where they have specific needs. So you could have the best law. How many countries? I've seen in my hemisphere so many laws of water just right there. Nothing happened. So we have to question that. Of course, we have to incorporate the ecosystem vision. Of course, that we have to do our best. We don't have to wait for the last data that tell us that we have to do it. No, of course, we have to do it. But we have so many challenges in between. And that's why when we talk about governance, we cannot talk only about the legal frameworks. We have to take in simultaneous the capacity, the building capacity of the institutions, the participation, the transparency, of course, and what I was mentioning regarding security about the knowledge, the information for where water is coming from. Otherwise, I don't see any possibility through a convention, through a law, or through our armed forces trying to implement that. We have to consider and we have to understand that the poorest of the poorest are right there in the borders. How many legislations in each of our countries have made a small, gentle indication on how open they are to negotiate transboundary water with their neighborhood? I don't see any. So this is, I think that we could talk a lot about the possibilities from our environmental rule of law for do many things, but I think that please, you who are in that area, consider that we have to bring the other groups. Why I hear a lot about networking, the effort of IUCN trying to build networks with many other actors in that regard. So I think that it is very important. The SDGs by themselves, they are nationally driven. What is the regional vision of SDGs? None. How you are going to reduce poverty in the borders if people jump back and forth from one side to the other one? Are you going to increase infrastructure if the water is in an aquifer that you don't know how much water do you have? How you are going to solve the problem of the depletion of the middle plain of the United States water? That's the reason why we pay $1 in McDonald's for one burger. It's coming. All of this is coming. So one thing that we have to understand too is that this is a dynamic type of issue that we have to see a lot of what happened in the future. The success of the climate convention is that we were able to model the future, and we understood better, with better and better information, how to negotiate and reach a real agreement. In water, we have no vision of the future, even though we have scenarios and many things like this. So I just encourage you to consider these other aspects, not only the legislation by itself, but how robust and solid this legislation must be too.
Thank you very much, Max. Carl?
Thank you. I think following on Max's comment, your initial question about how can the environmental rule of law improve water security, I would say that we have a lot of laws, and they're not working as we want them to. And the question is it due to the fact that the laws aren't appropriate, or the laws are somehow flawed, or they're not being implemented properly? And until you actually have compliance, you can't answer that question. And so I think the environmental rule of law allows us to better govern our resource, so we can figure out, in what ways do the laws or institutions need to be adjusted. The question of ensuring that water is prioritized, water security is very interesting. It's very controversial because, in certain respects, because when you securitize water, when you securitize things in the UN framework, that takes it into the realm of the Security Council, which is a very undemocratic institution. You have 5 countries that have permanent veto. And so there is an effort by the other 180 some countries to keep it out of the Security Council. And you don't want the Security Council butting into your own internal affairs. So I think water security is very difficult, but I think that's where the SDGs are so revolutionary. For the first time, a UN process says that peace is central to sustainable development. And it's a weak leg, but we have that 4th leg for the first time. So I think it's a very interesting question, worth discussing over beer. And the final thing that I'd like to say is on the question of rights. There's a question of helping countries to define what the rights are. There's also the question at the subnational level of customary law and customary rights. And we want to keep in mind that there's kind of this top-down, bottom-up, and they both have merit. But we need to remember that a lot of these countries are governed at the local level across large swaths of the country by customary laws, and we need to be thinking about what is the relationship to the statutory laws, and thinking about it more through legal pluralism rather than the statutes replacing the customary norms.
Thank you very much, Carl. Alejandro?
Just one comment, because if not, we will never finish. I mean, thank you for these interesting interventions. Just to complement or to build upon what you just said, Carl, and responding to the question from Worko, I think, the discourse is moving away from this idea of rights, right? Rights, my rights over the resource, and looking more and more into the benefits deriving from the use of the resource. And in the water realm, this has got a lot of traction here there is some means for
Means water.
yeah,
What do you
or
prefer?
means or whatever. So moving away from that, you know, sometimes antagonizing way of looking at the resource from the rights perspective and moving towards this idea of benefits that have, you know, more responsible approach. I think that the rule of law helps by way of providing clarity and certainty. You know, policies themselves as such, without a legal anchor, do not provide the certainty and the long-term sustainability that the law can give you. I think in all, we need, because of the situations and the challenges that these resources are suffering, holistic approaches, you know, not only focusing on one particular issue. And that's why I like very much of what you said, Carl, looking at other areas of law. So water law in isolation per se, you know, does not respond to all the challenges faced by the resources. We need to look at human rights law. We need to look at humanitarian issues. We need to look at security and military issues, and so on and so forth. And I think, you know, at the end of the day, we need to also start moving away from this idea that diplomacy at the transboundary level, so when we look at resources crossing boundaries, and all the challenges are going to be resolved by agreements between states. The agreements to be effective need the agreement of the users, and the users are not only the states, are the people. And at the local level, we also need agreements, and those agreements can contribute to the solution of those challenges.
Thank you very much, Alejandro. Now we will go to the second round of speakers, so I would like to give a round of applause to our first three speakers. And I would like to invite the next three speakers to the podium. They are Fernando Macias, who is the president of the Colombian Environmental Law Institute. Then Owen McIntyre, professor, School of Law, University College at Cork, Ireland. And Fernando Valcácer, professor, Catholic University of Rio de Janeiro. You can sit in any order you prefer. And of course, the rules are exactly the same. They will have each one 10 minutes to present, and the three of them will present, and then I will open the floor for comments, actually for questions and eventually comments. And the first one will be Luis Fernando Macias. Luis Fernando, the floor is yours.
Bon, alors, je vais parler en français, donc, parce que je me sens pas à l'aise en anglais, donc, même en français, mais je préfère parler en français. Lorsqu'on ne peut pas parler en espagnol, alors, c'est la première fois, alors, donc, c'est curieux, hein? Yes, le Spanish est retiré, oui. Bon. Alors pour ça, mais tout d'abord, j'espère que la personne qui traduit à l'anglais comprend mon très mauvais français, s'il vous plaît. Merci. Ok, d'accord. D'abord, je vais montrer deux petites... what's happening here? Sorry. Ok. Oui, c'est en espagnol. Bien sûr, je préparerai la conférence en espagnol, mais après, je vais parler en français. C'est des choses que je vais montrer. J'ai essayé de... Ça, c'est important parce que ce que je vois, c'est qu'il faut repenser tous les problèmes sur la biodiversité, les problèmes de l'eau, du sol, de la forêt. En 1897, un Colombien a défini ce qu'aujourd'hui on connaît comme le développement durable. Lorsqu'elle dit « Les considérations que je viens de faire ne sont pas attendues entre nous. Et nous avons conduit toutes ces affaires avec une grande imprévision. nous jetons, nous n'utilisons pas notre patrimoine et nous faisons une rupture avec notre conduit, avec la solidarité des futures générations. Donc c'est très important ça. C'est 1897. C'est important. Et en 1986, il y a un juriste colombien aussi qui a montré l'importance de l'eau et la forêt pour tous ceux qui comprennent l'importance économique de l'eau. Alors, pour ça, je crois qu'aujourd'hui, nous sommes dans une nouvelle situation de ce qu'avant était déjà prévu pour les juristes, pour les chercheurs, pour les scientifiques. Et le problème, c'est la water scarcity. This is the problem. But mon conférence est préparée pour montrer une autre chose. C'est le problème de la sécurité nationale. Lorsqu'on parle de la water scarcity, because oui. Le problème, c'est le suivant. Aujourd'hui, l'eau, c'est un bien économique, une ressource naturelle, et on parle aussi de l'eau potable. Ce sont trois aspects de même formule chimique, H2O. Et qu'est-ce qui se passe avec ça? Ça dépend du point de vue qu'on choisit. Si c'est l'eau comme une ressource naturelle, c'est le problème pour l'agriculture, l'énergie, ou bien aussi l'industrie. Si on parle de l'eau potable, c'est un problème de service public. Et si on parle du bien économique, le voilà, c'est ça, le bien économique. Mais et ça devient aussi l'eau en intérêt des États. Un intérêt des États que ça nous conduit à penser dans la sécurité de l'État. C'est-à-dire, lorsqu'on parle du problème de l'eau, du problème